try to be about 10 minutes each. Dr. Nudrat Piracha, please.
Bismillahirrahmanirrahim. I would like to begin, first of all, by expressing my gratitude to all the honorable speakers, the viewers, our guests, ladies and gentlemen. The attendance here today demonstrates, and what we have heard today demonstrates, that one would deliberate in vain if one was to try to establish that there is no need for an ADR system to supplement the existing system. Currently, access to justice and time-sensitive justice is simply not possible for the average litigant. The statistics are alarming. There are 2.5 million cases pending in the courts of Pakistan, about which 53,000 cases are pending in the Supreme Court alone. Small contractual disputes take over 1,027 days in commercial disputes, and by a study conducted in 2019, 54% of the cases that were studied, civil cases, they took over 3 years to resolve. For countries desperately in need of foreign direct investment and business creation, access to justice plays a major role in establishing a conducive economic climate. In fact, the justice system in any country, as we heard Judge Brower say, is a major reason why foreign investors are reluctant to make long-term commitments in states where there are systems which are not reliable. So our major problem within our courts is the unnecessary number of cases which are pending before the courts that do not require litigation for their resolution. However, they cannot be resolved in any other way because these issues still need a mechanism of enforcement to ensure that the compliance is made with the commitments undertaken under these ADR processes. Currently, litigation is the only widely accepted method of parties to seek resolution of their disputes. That is where ADR comes in, specifically court-annexed ADR. This is where the court directs the parties to the ADR center to resolve their disputes or to the neutrals to resolve the disputes through amicable means. This is done with the assistance of facilitators trained to resolve conflicts, as Justice Aurangzeb mentioned, the neutrals who are being trained for the Islamabad High Court. The agreement reached by the parties is recorded by the directing court as rule of the court and given a binding force. This approach used across the world enables parties to reach speedy resolution, significantly reduces the costs of the parties and the courts in conducting the trials. And it reduces the burden on the courts to resolve issues that can easily be decided amongst the disputing parties through facilitation of trained neutrals. So essentially, the ADR system works in tandem with the justice system and offers the prospects of reducing delays and improving access to justice. ADR offers specifically trained neutrals, expeditious out-of-court settlement, and binding agreements enforceable through the courts. Even in Islamic jurisprudence, ADR is a preferred method for redressing grievances. ADR plays a critical role in preserving the relationship between parties. Thus, family, commercial, and community disputes are among the disputes that could benefit most from the ADR process. It provides parties autonomy in resolving and devising solutions and results not only in preservation of relationships, but has a significant cost-saving effect at an individual level. For the Pakistani courts, it would reduce an immense burden of pending cases while preserving the writ of the court and its judgment onto all parties, a winning formula for all. ADR universally is accepted as an effective legal form of dispute settlement. Given that a prominent majority in the Pakistan judiciary, as we heard today, it believes in the benefits of ADR, where do we stand? How do we formalize this system in Pakistan and implement effective ADR processes? Some general roadblocks to implementation of effective ADR in Pakistan have been, first, in relation to court-annexed mediation systems. While now there is a legal framework that exists, conventionally there has been a lack of capacity and proper training for the legal fraternity and the stakeholders. In addition, the absence of sustainable systems, a forward-looking system design, and ownership by relevant institutions has undermined any efforts in the direction of institutionalizing ADR and implementation of these ADR laws. Second, to the limited extent that arbitration, which too is a form of ADR, is part of the laws of Pakistan in the form of Arbitration Act 1940, it has had little success because as far as domestic arbitrations are concerned, there is lack of capacity and specialized training in the field, lack of trained arbitrators, and the legal framework is the major cause which is obsolete and deficient, calling for revamping of the arbitration laws and resorting to institutional help for ad hoc arbitrations. Third, international arbitrations have suffered due to, in addition to the problems I just mentioned, the distrust in international arbitrators and the arbitration systems, and at times due to judicial activism. This calls for training, protocols, guidelines, superior courts encouraging expeditious arbitration processes, and giving sanctity to the awards and arbitration agreements. Last, in investment arbitrations, there has been lack of capacity amongst various stakeholders, centralized efforts for positioning Pakistan to set up its best case, checks and balances on appointments of counsels and arbitrators, compromising the best of Pakistan's cases. Dispute resolution mechanism grounded purely in national systems for investors and Pakistan's present model bilateral investment treaty are highly unlikely to have the traction for investors. This state of affairs calls for trainings, system design, government and other institutional support, building of appropriate legal framework and infrastructure, social entrepreneurship, setting up online dispute resolution systems, and private sector working hand in hand with court-annexed centers to resonate the experience of countries like Turkey, Italy, and Africa. In the past few years, various initiatives have attempted to introduce ADR methods in Pakistan. There has been a legal momentum towards ADR provisions in the federal and the provinces, resulting in ADR law being introduced besides ADR provisions in multiple laws. Despite the efforts of justices, NGOs, and the legislature, the level of knowledge and use of ADR continues to be insufficient. The sporadic efforts of single persons and organizations have had only a transitionary effect. Thus, lack of information about the dispute resolution systems, other than litigation, and a center with capacity to provide the required services has restricted people and businesses from using the whole spectrum of dispute resolution processes. Recently, the superior courts, as we heard today, have embraced the idea of facilitating the use of ADR. Punjab has set up a model, and as we heard today, the Islamabad High Court is on its way of setting up an exemplary model for everyone. What we require now is formalizing this system. It requires setting up ADR centers, court-annexed ADR centers, and other centers, working across legal and political lines to connect it with the formal court system. This ADR-based legal system will work in tandem with Pakistan's current legal system to provide speedy access to justice. I would like to end on the note that I stand before you today with a dream of a Pakistan where the new generation does not inherit the litigation commenced by their predecessors. A Pakistan where litigants do not knock on the doors of justice, but where justice is made available at every doorstep. But this dream cannot be realized without your active support and involvement. Thank you.
Thank you very much, Dr. Piracha.